So my name is Sharon Cartagena. I'm the directing attorney of the Child, Youth, and Family Advocacy Project at Public Counsel. So I have a team of about 25, and we work on issues really affecting custody, particularly in Los Angeles, but we do work around the state. I'm also a mom of 2 students at the Pasadena Unified School District and a PTA member. We created this presentation that you're going to see based on the experiences that we've had since the beginning of the year last year, actually representing families facing separation in the California court system. So actively going to family court, to probate court, to dependency court, and helping people figure out what is very, very complicated when you're also dealing with an immigration issue. We've represented people who want to stay together, who want to reunify in their country of origin, and who want their children to stay in the United States, because parents have different goals for what they want with their children, and we wanted to make sure that our community education materials really focused on what the individual family wanted for their goal. So, next slide. So, yes, thank you. The first thing that we learned was that misinformation is rampant. You may have read in many, many different articles and magazines that kids are entering foster care. That's actually not true. Kids are not entering state foster care as a result of deportations, and we're going to talk about why that is and how good that is. Power of attorney is not the best way for folks to plan for the care of their children in California. And if I'm on a lot of mom Facebook groups who are advising everyone to do a power of attorney. That is not what you should do in California. Temporary guardianship is also not what you want to do, because temporary guardianship in California is not temporary. There is no standalone temporary guardianship in California, and if you consent to one, which people are, I think, well-intentionally advising people to do, you may permanently lose your children. And having sole custody does not mean that you can move your children out of the country. So I'm not currently representing a mom who has sole custody, who has a restraining order. Father, because of some serious issues, only has supervised visits. She's fighting him for custody because sole custody does not mean you can move your children without permission of the court. So next slide. So we developed this for community members, for lawyers, for social service folks, to get better information out there. And I'm really hoping today that if you like this presentation, if you think that it would be useful in your community, that you contact me, because I have team members willing to do virtual or in-person presentations all around the state. I'm also hoping you'll share this information parent to parent, because I can stand on as many Zooms as possible, and sometimes people don't listen, but they may listen to you as a parent, a parent of a classmate, right? They may listen to you when you say, hey, I know temporary guardianship seems good, but it's not maybe what you think. Don't spend $500 on a power of attorney that's not legally valid in California. So will my kids go into foster care if I'm deported? I'm going to answer that right away, because that's the scariest thing. It's probably not. Let me get to the page on that. So most kids will not enter foster care simply because their parents are deported. CPS will only get involved if someone calls the child abuse hotline and alleges that the parents have abused, abandoned, or neglected their children. And ICE is actually supposed to call the child abuse hotline when they detain parents, but so far they haven't been doing that in California, and thank goodness. However, even if they do call the child abuse hotline and CPS comes out and investigates, the state has told local CPS agencies, don't put kids into foster care if the only issue is a parent's deportation. Work with the families to create a plan to avoid foster care. And so far, that's largely happening. In LA County, I'm aware of one case, which we'll talk about later, where a child has entered foster care as a result of a parent's deportation. And the reason really is plans, creating a plan. So just really quickly, for a child to enter foster care, there has to be that call to the hotline, an investigation. The investigation has to determine that the parent did something bad, in this case, abandoned their child. And you can't actually legally say abandonment unless a parent has left a child without a plan. If a parent has made a plan, or even makes a plan after the fact, it's not abandonment, and a child should not enter foster care. And so it's so critical that families have really good thought out plans so that they can avoid a child entering foster care. If a child enters foster care, it's really a fast track to permanent separation. Although it's possible to reunify out of country, it is really hard to do. And parents are under a timeline set by the federal government to reunify within 2 years or qualify for an exception, or they could lose their parental rights permanently. So foster care is not somewhere that we want kids entering. We want to have families prepared with plans so they can avoid that outcome. So next slide. So again, what do you do to reduce your risk of CPS involvement? Is make a plan. But it should be a thought out plan. It should be a short-term plan and a long-term plan. Short-term plans are what to do during detention. And so let's talk about that. Detentions happen without much notice. Folks may be at the bus stop. They may be, in line for a child drop-off at school. They may be in a lot of different places and suddenly and unexpectedly put into ICE detention. Folks who are not expecting to be detained. So I have 2 cases right now. One is a DACA recipient. The other has a U visa. They were both deported and are now in their country of origin. They thought they were safe and they did not have a plan because they had legal status. But folks who are at any risk really need to have both a short-term and a long-term plan. So next slide. So getting your plan into place. So the first thing is to talk to potential caregivers. You want to have a caregiver who is able to meet your child's needs, who is ready to stand in at a moment's notice. If you're detained at a bus stop, you need someone who's going to be able to pick up your kids that day. You also want to talk to that person about your expectations, about their expectations. Unfortunately, the person who you choose to be your caregiver is going to have a lot of power, the power to actually cut off communication with your children if they want to do so. And the cases I get involved in, usually something went wrong and that happens. And that's usually because resentment has built up. The caregiver expected one thing, maybe they expected funds to be sent, they expected a certain amount of communication from the parent, maybe the parent expected the caregiver to keep their child enrolled in their homeschool and the caregiver didn't follow through with that. That resentment can lead to permanent separation. And so it's critical that really you think through who the caregiver is. Do you have a good relationship with them? Can you communicate with them? Will they stand up and take care of your child until you're able to reunify with your child if that's what you want? In the one case in LA where a child entered foster care, it was because the parents, the caregiver the parent chose, actually called foster care and said, I can't take care of this child anymore. After about 3 weeks, please take them and put them into foster care. And so that's why it's critical to really think through who the caregiver is going to be. It's also important to talk with children about your plan. Children know what's going on. I know my 10-year-old, we live in Sierra Madre where there has been no ICE activity. My 10-year-old knows what's happening, right? It's important for kids to know that if they even think their family's at risk, that their family has a plan. Unfortunately, it's also important for children to know so that if a parent is picked up while the child's with them, that the parent can tell an adult that's around, here's my parents' plan. Please call my auntie or my grandmother. They're my adult that you should call if this were to happen. It's important that parents inform their broader community. So their neighbors, their family friends, anyone who is important to them what their plan is, because once they're detained by ICE, it may be days before they're allowed a phone call. And days are not, if a child's left at school, you all know, the school's not going to wait days for the parent to show up. And so critical that multiple people know what to do if this were to happen. And update all emergency contact information. The emergency contact information is what allows people to pick children up from school. And so if you don't have updated emergency contact information, it's quite possible that the school district could call CPS. I know school districts don't want to do that, but it is really critical that the emergency contact information has multiple names of people who are allowed to pick the children up, so you're not in that situation. I was talking to LAUSD because I'm doing a series of presentations for them, and they said the majority of parents in their school district have no one listed on the emergency contact list. So it's really, really important to encourage people to put not just one person, but several people on that emergency contact list so folks aren't in the situation of not having anyone who's allowed to pick up their children. Next slide. Oh no, I'm running out of time. Okay, I'm going to speed up a little bit. Gathering documents. All of these documents, really important to have. This PowerPoint and our parent workbook is listed in the Dropbox or the link that folks have. And so go through, think about what documents parents can get. The reason I'm saying this is a lot of these documents are easy to get if you're a parent and really hard to get if you're not one. And so it's really critical that folks have these. And I'm going to put an asterisk on passports because it is really hard to get a passport if the parent's not in the country. And unfortunately, I now know how to get passports if a parent has been deported, but it is a very long process to do so. And then legal documents. So next slide. Next slide. Okay, so not a power of attorney, but these documents. These are the documents you need. A caregiver's authorization if you're a relative, and if you're a non-relative, so a second cousin, a godparent, a neighbor, they need a caregiver's authorization plus separate medical decision-making powers. So next slide. This is a bad document. So this is the power of attorney, the short-term guardianship power of attorney. I see these all the time. They're very misleading. One, they cost like $500. They say guardianship. They are not a guardianship. The only thing that you can do, you can't set up a guardianship in California without a court. You can't transfer custody in California without a court. So although this says short-term guardianship, it is not a guardianship. However, sometimes it contains something called a nomination of guardian or consent to guardianship. And although the top of the document says short-term, when you sign a nomination of guardianship, you're consenting to permanent. And so people sign these things thinking it's a short-term guardianship. It's not that, but it is potentially agreeing to suspend your parental rights permanently. And it doesn't provide you with anything that a caregiver's authorization already provides you with. So people are paying, $500, $600 for these documents that really do nothing more than a free document does. So next slide. A caregiver's authorization affidavit is what you need. And I'm going to skip this slide. Okay, this is what it looks like. It's really easy to fill out on purpose because we want people to be able to do them, to stand in an emergency when parents need them. It does not need to be notarized. It does not need to be signed by a parent. And it does not need to be stamped by a court. And there's a QR code to a copy of it. But again, these slides are in your materials. The reason that caregiver's authorization affidavit is so limited is because, right, you don't need a parent's signature. We don't want people to sign away custody and get all these rights without a parent's signature. But we do want people who are taking care of children unexpectedly to be able to, one, enroll them in school, which is what a caregiver's authorization can do. And the only other thing a caregiver's authorization can do is allow relatives to consent to medical decision-making. So it's important for those two things because those are critical emergency things. If you were caring for a kid and they need to go get antibiotics for a strep throat, you don't want to have to wait and find a parent to sign. You want to be able to do that. But they don't do anything more. And that's why they're very low barrier. They don't need to be notarized or signed by the parent. They're very easy. However, if you're caring for a child for a little bit longer, you may need some additional things. Third-party authorizations. So a third-party authorization for medical consent is if a non-relative is caring for a child, they actually do need this third-party medical consent to be able to consent to stuff. So if your plan is for your neighbor to care for your kids, you probably do need this other form that needs to be signed by the parent in advance. It does not need to be notarized by law, but sometimes we tell people, you know what, be careful, get it notarized, although that's, again, not required by the law. You may also want this other designated educational decision-making authority. This is really if you've got kids with special needs and pretty severe special needs, you may want this additional document. Again, QR codes to get these documents. They're all relatively easy to fill out. You do not need a lawyer to fill these out. And so parents should not be spending money. If a family is impacted by a deportation, they're going to need to save their money. They don't need to spend $800 for a lawyer to draw up paperwork. They're going to need that $800 for a lot of other things. And then there's a travel consent form, which I'll talk more about later, but check it out. So next slide. So what about AB 495? So AB 495 was a bill that my agency worked on. I actually wrote the text of it. After being amended, it did not make any significant changes to the caregiver's authorization affidavit. So we really wanted it to. We really wanted the AB 495 to allow godparents and close family friends to be able to step in, because we know a lot of folks who were impacted by deportation may not have close blood relatives in the US. And unfortunately, that did not pass. And so AB 495 did not make any significant changes to the caregiver's authorization affidavit. So next slide. Long-term plans. So we just talked about documents that folks need for a short-term plan. So in my experience, when people are detained by ICE, they're detained and held in detention for at least several weeks, usually several months, right? So they're unable to care for their child for, 4 months, 5 months, 6 months. After that, they're either released, which is very, very rare, released into the US, or they're deported, or they agree to something called a voluntary departure, and they're back in their country of origin. After that point, that's when families have to start thinking about their long-term plan. And so there's two main options. There's reuniting in country of origin, or there's kids staying in the United States with a long-term guardianship. For folks who want to reunite in country of origin, there are kind of two pathways. One is called joint repatriation, which is where ICE actually helps a parent get their children and they get on a plane together and leave the country together. This is very hard to do. It also means entrusting your child to ICE for 24 to 48 hours, where your child will be in ICE's custody without you there and without someone else there. But sometimes it's the best pathway for some people, because family-led reunification can be impossible for some families. So family-led reunification, one, you're going to need someone who can travel outside of the US with your kids. And I can tell you a lot of my clients don't have anyone who can travel outside of the US to take their kids to them. You're also going to need to get a passport. Sometimes ICE wants you to get that with a joint repatriation. Sometimes they don't care. You don't, just never know. And you need a notarized letter. If whatever your plan is, people need to think about who will care for the children while the children are waiting for the parent to get out of detention. They need to know not to consent to a guardianship. A guardianship suspends your parental rights. If you agree to a guardianship because you think it's a temporary guardianship, you will not be reunifying with your children. And you need to know if there's existing family law orders. If a parent, even if they were a custodial parent, is detained, it's very possible that the other parent may decide that they want to have the child and fight them for custody, file in family court for custody. It's also possible that other relatives may step forward and file for guardianship and fight the parent for guardianship, even if there is nothing to allege against the parent other than the deportation. And that's primarily the cases that my team is litigating right now. Parents who were the custodial parent were deported, wanted their children, and someone stepped up and is fighting them in family court in California. Those are very, very difficult cases to litigate. They have to be litigated here in California, and my clients are appearing via WhatsApp. If you're talking to folks who are in that situation, think they could be in that situation, it's critical that they see a family law lawyer right away. You need to prepare for these cases in advance. Tomorrow I'm going into day 10 of a trial on this. You need to have witnesses, evidence, and everything lined up, because they are hard cases to win. And folks who have not spoken to a lawyer are really going to have an uphill battle to reunify, even if they were previously custodial parent. So next slide. Again, if the child's other parent doesn't agree, even if I've had cases now where parents were together in a relationship, the deportation broke them up. The remaining parent said, you know what, I'm going to keep the children here. I'm going to cut off all contact. If a parent doesn't have active family law cases, but that's their situation, they think they may be in that situation, maybe they think their partner would want to keep the children here, also see a lawyer right away. Really critical. These are hard cases. Next slide. So the other option is to transfer custody via probate guardianship. A traditional probate guardianship completely suspends a parent's rights and transfers those decisions to somebody else. It's a great option for folks who know they want their kids to remain in the United States. It's a great option for teenagers, especially, who may want to be on somebody else's health insurance or thinking about college. But it has limitations in that it does totally suspend a parent's rights and it can be hard, if not impossible, to regain custody. And I did represent several people who agreed to a probate guardianship, a traditional one, were deported, were able to return to the United States, came to get their children and found out they couldn't. Because once a probate guardianship has been issued, if more than 6 months or a year has passed, it is very unlikely that you will regain custody of your children. And so it's really important that people really know what this is, because it's a really good option for some people, but a lot of people go into it with a lot of misinformation about what the long-term implications are. So next slide. So the thing that AB 495 did that is so exciting that a lot of people didn't pay attention to because they were really paying attention to the caregiver's authorization affidavit was it created this new kind of guardianship called joint guardianship. And this kind of joint guardianship, it used to only exist if a parent was terminally ill, and it let parents and non-parents share custody. And now, under a joint guardianship, as of January 1st, parents and non-parents can share custody if a parent is going to be temporarily absent due to incarceration, illness, military service, or immigration proceedings. And so this is a new way for folks to share custody, to not completely lose custody of their children if they think that they'd like their children to remain here, but they want to still be involved maybe via Zoom in their children's lives. Next slide. You cannot set up a guardianship in advance. And so we operate a clinic at the courthouse in downtown LA, and so many people have been coming in and saying, I want to get that guardianship right now because I may be at risk of a deportation. If you set up a guardianship, it immediately suspends your parental rights. So you can't do it in advance. You don't want to do it in advance. You don't need to do it in advance because you've got a caregiver's authorization affidavit plus those other authorizations, and that will keep you covered short term. But what you can do is you can do the nomination of guardianship form. The nomination of guardianship form lets you tell the court who you want to be guardian. And so you fill it out, and then the person you chose to be your guardian will go to court with that form and the rest of the paperwork you need to be guardian, file it, and I'll tell the court, hey, the mom or the dad or any parent says, this is who I want to be the guardian. The court doesn't have to follow it, but they do have to give it due weight, right? So it's sort of the best planning is you have your caregiver's authorization affidavit, your other authorizations if you need them, the nomination of guardianship, and that puts you on the pathway towards a guardianship. Or you have your caregiver's authorization affidavit, your other authorizations, and your plan to reunify. And hopefully you've spoken to a family law lawyer because, believe me, a year ago, I didn't know how complicated this could get, and I spent the last year learning. So I would love it if you liked this presentation. I did it really, really fast. I can do it a lot more in depth with more client stories. I would love to come out to talk to folks in your community. We can do this presentation in English or Spanish. We can do workshops to help people prepare documents. And if you are looking at your district's websites and you're saying, hey, we need more information about this, right? I'd love to talk to you about what could be on your district's websites and how your district could support families in thinking through how to be prepared. So, okay, let's see.